Here we are in week 6 of the legislative session, down in this soggy town y'all send me to. And last week's most notable event happened, for me anyway, happened on Friday. We had tried in a parliamentary maneuver in the Judiciary Committee, of which I am now the former chair, currently the ranking Democrat, to force the Republicans to hear 5 bills. All of them common sense bills, none of them of the kind that would be controversial, even to the Second Amendment folks that feel that everything is governed by the Second Amendment regarding guns, and so we can't do anything. No, these were reasonable kinds of things that in another climate, many of them would have had 9 votes. Let me give you an idea of how common sense they were. And I chose these bills purposefully because they don't raise the big issues. They test whether our Republican colleagues, who have a majority on this committee, are willing to consider common sense, non-regulatory, non-mandatory bills, things that would allow people to make their lives safer. Now, would these bills in themselves have made life safe in the state of Washington from gun violence? No, that wasn't my purpose. I was trying to test around the edges whether they would accept the common sense stuff, and the answer is no. These 5 bills, I got them here. Let me just give you a little gist of what they were. First, this is Senator Kaiser's bill that would allow a person who has a homicidal or suicidal person in the house, take the guns, give it to the sheriff for 30 days for safekeeping. It can be re-upped so that 30 days can be 60 or 90. You can keep that as long as you want. The sheriff or police chief keeps the guns, and a homicidal person does not have a gun to which there's easy access in a moment of desperation. Common sense? The vote was 5-4 on party lines. I'm sorry, 4-3 on party lines against. This is one of my own bills, and this is a bill that I filed long before gun issues hit their recent crest after the Newtown massacre. I filed this bill last year. It's simply a way to get to the criminal negligence that some folks exhibit around guns, allowing them to be possessed by children accidentally. You may recall the incident in Bremerton where little 8-year-old boy is living at home with his mom. Mom has a boyfriend who has a loaded gun, loaded with the safety off in the living room. Kid sees it, puts it in his backpack, takes it to school. He's going to run away, but he wants the gun. At school, he throws the backpack down on his table. It discharges, almost killing a little 9-year-old girl who's sitting in the next seat. The criminal negligence of the boyfriend leaving the gun there is the issue. The boy, 8 years old, doesn't have criminal responsibility. Boyfriend does. The prosecutor in Kitsap County had to file an assault charge against the boyfriend, which now is being litigated, it's in the Court of Appeals, as to whether assault is the proper charge. Personally, I think it's not. Usually an assault requires intent. Well, the boyfriend didn't intend to kill the girl or shoot the girl. The criminal negligence is what this bill was getting at. Nobody in his right mind should have a problem with that. But in the year 2013, everything is about guns, and this bill does obviously relate to firearms. So you got it. The vote was 4-3 on party lines against. Next bill, Senator Darneal's. When a person commits a felony, he or she automatically loses the right to possess a gun. You can get it back by going to a judge. Under the current law, the judge really has no discretion. So long as you show some evidence of rehabilitation, you're 21 years old, you're not mentally ill to the point of being dangerous to self or others, he or she must give you the gun back. This allows the judge some discretion. The bill, I'm reading this, grants discretion to the courts to consider the restoration of firearm rights to a person who's been found not guilty by reason of insanity, or has been involuntarily committed for mental health treatment, or in another case where you're simply requesting the restoration of rights. Should the judge be able to consider, hey, wait a minute, you meet the statutory requirements, but what you're telling me is you got some hostility going on and you want the gun back, judge should be able to say no. You guessed it, 4-3 against. Senator Colwell's bill, reckless endangerment from the use of firearms. Should the reckless endangerment statute be amended to allow a court to convict, or jury to convict, on the basis of the same criminal negligence that I was talking about before? Different version of getting to the same place? You guessed it, 4-3 against. And the last one, simply creating a task force. This is, okay, too often in legislative circles, when we can't get the bill done, we amend it to include a study. 4 legislators, 1 from each caucus, experts in the field, judges, whatever, and we'll study the issue, and recommendations will be made in a future year to the legislature, and we hope that by having the recommendations come from some neutral body, that they'll gain credence and will be accepted later. It's a punt. 4-3 against. In other words, these Republicans are so blinded by the outcry about Second Amendment violations, by which they mean any legislation involving guns, that they cannot divorce themselves from that, look at these bills on their merits, understand the common sense approach to public security, and say yes. They can't do it. This is bipartisanship in the Senate. This is the new bipartisan majority. I'm sorry, this isn't bipartisanship. This isn't even rational or intelligent. This is good old-fashioned Republican no. Rigid, mindless no. Thank you.